from the day when you came to Durango and you stood with the other AGs in Rotary Park, since then, just what efforts have been done on part of your office?
I came down a week to the date, and then it was about 2 or 3 weeks later when we came and did the tour of the mine. I came down both times partly because I'm a visual learner and I wanted to see the lay of the land and understand as much as I could what had happened, and talk to the people who were on the site. It was more fact-finding for me than anything, and I knew that the scene would change over time, as it does when you have remediation. It would never look quite the same again, so I wanted to capture that in my head, Peter, and also wanted to talk to people in the community to the extent that I could, and on an albeit limited basis, because everybody was busy and functioning in their emergency management roles. But I wanted to hear from people about how they felt on the ground, whether they felt EPA was being helpful and being responsive, whether they felt there were things that needed to happen just in order to relay that information and be helpful from a lawyer perspective. In the time since, I would say the majority of our involvement until recently here in the AG's office has been in supporting our clients, Department of Natural Resources, CDPHE, and the governor's office, in whatever they needed to do their additional monitoring and fact-finding. And clearly the first weeks and even months, I think, have been spent with everybody trying to figure out just what happened, and go back and also look at the history of the mine and say what caused the backup of water, the pressure that then caused the blowout when people started moving rock and dirt around. And I think some of that is still going on from our client's perspective. I think the emphasis has been on the policy questions and on the governor in his role as the policy leader of the state, saying, to EPA, all right, let's look at the situation, complicated very much by the fact that there are so many mines in that area that are also discharging water on a daily basis, and the Superfund designation conversation. I have really felt like it was important for the NPL listing request to be made before we get too far down the road and talking about litigation. If we are listed, if the site is listed as a Superfund site at the Bonita Mines, and we can get money, resources, and remediation, then it changes what you need to do in terms of litigation. So the shift and where we started to get more involved has just been in the last few weeks after both New Mexico and Utah filed their NOI letters, their notice of intent letters. And while that doesn't mean that either state or both is necessarily going to file a complaint in federal court, it certainly means they could. And so it means that my office and the lawyers kind of shift from being counsel to the agencies to preparing if they need to litigate. And it's a little bit different mindset. You ask different questions, you prepare and look at evidence differently. So we have put together a 10-person team in the office of lawyers with different specialties that are pertinent to work on this. They're a Gold King team. We have environmental attorneys who know RCRA and the Clean Water Act. We have a governmental immunity specialist. We have our tort litigation, civil litigation litigators who are heading up the group. And they are meeting regularly with the client And we continue to have weekly discussions with the governor's office. Our senior staff in the governor's office always talk weekly about a variety of issues, but Gold King clearly is near the top of the list. So we're looking at what we need to do to be ready if in fact a lawsuit is filed.
Yeah.
And then I also sent the letter to the EPA administrator on behalf of individuals and businesses that have made claims under the Federal Tort Claims Act process. I sent that letter because, as far as we know, there hasn't been any action.
There has not.
By EPA, and so, and it was a question you were asking, and we were all saying, all right, yeah, Governor, I think it's time. It's time that we did a letter and said, give us a status update. While it may not be the state's responsibility, I can't represent those individuals. I do feel a sense of responsibility to them to use the position I'm in as Attorney General and say to EPA, give us a status update, which hopefully means write some checks. So that has happened.
Response yet?
No response yet.
No surprise?
It takes a while, I think, to get a letter turned around out of Washington. Lots of folks lots of hands go into that.
Oftentimes those letters, they come from high-ranking officials such as yourself, and then nothing comes of it. I mean, what sort of weight does it really hold?
This is a situation where the more people there are putting pressure on EPA, the better. And you've really tracked what members of Congress are doing in that regard. They may have the ultimate leverage because they hold the purse strings. So I think what you'll see is all of us just sort of working together and mounting the pressure on EPA if they don't start acting on individual claims. And then the other thing I wanted to mention that you may not know about, so we have put together, I have to look at the name of it every time, Spring Runoff Preparedness Plan. It's New Mexico, Utah, Colorado, the tribes, to do short-term monitoring for several months as the snow melts, and we want to see what's happening with the water and the fish and the soil.
What sort of role does your office play in something like that?
We're just advising the client.
Yeah.
And obviously it's important information for us to have going forward if there is litigation we need to know.
So speaking of that monitoring plan, it was kind of announced on the same day that the EPA announced their own, what started as a long-term monitoring plan, but now is a year-long monitoring plan. I know obviously you're not the environmental expert, and I would never ask you for, the science behind whether a year is enough, but, you're going to have to eventually potentially put the pressure on if we want more. They may come to you to send those letters.
Here's what I know, Peter. The EPA has put $2 million on the table for the states and the tribes and said this is for your long-term monitoring. I don't know that there is a definition of what that long-term is from EPA, but I think we've already told them that's not long-term. In conversation, we need environmental sites often have 15 years of monitoring. So I think that's yet to be worked out, and I think, frankly, if there is a Superfund designation, it plays into that and could impact how long-term monitoring is done.
Right. Absolutely. So speaking of Superfund, that was obvious. You said it yourself. That was huge, massive hurdle to overcome. Even just getting the locals involved in the governor's office. What role is your office playing now on implementation? Obviously, first the EPA has to back it, and then there's years of it potentially. There's going to need to be a level of accountability. The locals want to make sure that they're protected. I imagine that there's legal maneuvering in there as well. I mean, tell me about those conversations.
I think there certainly can be. There really has not been conversation that I've been involved in. And I'm sure there's been some chat between our lawyers and folks, particularly at the Department of Natural Resources, because there always is when there's a Superfund designation. And that doesn't happen very often anymore. You have a new generation of attorneys in this office who may not have seen a Superfund case. And the folks who did Rocky Mountain Arsenal, for example, many of those folks have retired. And so you've got to get educated.
Yeah, that's interesting.
In that form of law. We downsized that unit several years ago because we were closing up the cleanups at so many of those sites. So this is starting something fresh. Our role primarily is to advise the client in these situations, but I think we know that in the past, historically, with some of the Superfund sites, we've ended up with litigation, but it usually happens after a decade or so. So I don't think it's imminent, and obviously the whole notion of Superfund is that you have a collaborative process to clean up a site, and so litigating in the midst of that is not necessarily helpful.
What have those lawsuits usually been like? That you said 10 years after.
They're protracted.
Yeah.
And it's generally enforcement. Oftentimes it comes from citizen groups.
Yeah.
So you have environmental groups who say, you're not cleaning, the federal government is not cleaning this up
right.
to standard, and so we're not going to be able to put wildlife habitat here the way that we thought we would be able to. Those tend to be the sorts of conflicts that you have.
Makes sense. Yeah. This lawsuit from New Mexico that is pending, I mean, you touched on it, but I mean, what's sort of happened since, you stood there with New Mexico, literally arm in arm, in the park in Durango, to the point that they felt the need, I mean, clearly it's not a unifying effort anymore. So what kind of happened between then and now that you think New Mexico has even sent these letters in the first place?
And just, first of all, I'll say it was no surprise.
Okay.
That New Mexico, and Utah has also sent a notice of intent letter.
Okay.
When
did Utah send that notice, by the way?
February 26th.
I wasn't aware of that. Okay.
So that is just what it says. It puts the state, it puts the
on
parties
notice.
on notice that they may file a lawsuit. New Mexico has said that what they are really concerned about is having monitoring and knowing that if there has to be remediation down the road, there will be. I think they are as concerned about the NPL listing and the fact that it will help them long-term if Colorado is able to clean up these mines and the wastewater spillage. So even after filing a notice of intent, New Mexico has been talking to our folks regularly, their environmental department and our Department of Natural Resources.
So it's not like it's shut down, though.
It hasn't shut down communication, and we've been negotiating the spring runoff preparedness plan all the while. And I assume Utah's is more recent, but we have conversations with Utah on an ongoing basis, and I see their AGs at conferences, and we are very cordial. When I say it doesn't surprise me that they went ahead and filed their NOIs, I think I knew that at some point, if we weren't able to all work together early on with EPA, that we would have to take different positions because we're in different situations. I mean, both New Mexico and Utah, being downstream, obviously are saying we want to deal with the consequences of what happened upstream in Colorado. In Colorado, we have our hands full with many more issues than the downstream states do. It's much more complicated for us. There are more parties involved, and the sorting out of the facts and of the science is going to take a while, and we know that because we're in the midst of it. But I think for New Mexico and Utah, they had the time to focus on this and say, we want to preserve rights and file notice of intent letters.
Mm-hmm.
And it's probably a way for them to leverage negotiation and getting what they want in terms of monitoring and resources from EPA.
So
for
where's our
monitoring.
leverage?
That's our leverage.
Yeah.
You know, I think the thing is, we don't have to sue at this point in order to have some leverage. And our leverage is the site's here. We all need each other to cooperate, particularly for the NPL designation. The governor, for his part, from a policy perspective, saying, you know, that he's able to work with EPA and with the administrator and get things done, and there's certainly evidence that that's true. So at this point, it hasn't been necessary for us to take a different course of action.
The only reason I ask is because, you know, there are these EPA's got one account of how this went down, and the state has a very different account. Mike King, you know, he left at a wonderful time. You know, he has a very different account of how this went down and what our role was and our presence there. So if the EPA is saying this, you know, in their reports that, you know, Natural Resources or Bureau of Reclamation specifically was on scene and backing certain plans, you know, at what point do we need to interject legally and say, no, like that's not the case?
Litigation, it's an important tool that attorneys have, but negotiation is equally important. And as I said when I was down in Durango, I hope it isn't necessary for us to sue. I hope EPA steps up and does the right thing, and I still feel that way. That was my hope, because once you start litigating, the tone automatically changes and sometimes irrevocably. I think part of what's interesting to me to observe is the role that Congress has had in this process of fact-finding. I mean, they are in a fairly unique position to get information, although it's been a struggle for them as well.
Subpoenas were issued.
But they hold purse strings and they have subpoena power.
Yeah.
And certainly they have noticed the discrepancy in factual accounts from the two different reports that were done of the incident. And so this is typically what we see after an environmental incident, is unless something is extremely clear cut, and I haven't seen one of those cases yet. It may look BP Deepwater Horizon. Yeah, I heard recently at one of the AG conferences there was a report on that litigation from the Louisiana Attorney General, and what looked to me like, okay, that's obvious, you know, who was responsible for that, wasn't at all clear once you get into the story. So part of what we're experiencing right now with different folks giving different accounts, I think is probably typical of human nature. Everybody was at the same scene, but they saw different things and experienced it in a different way depending on their role.
So what's that mean for an outcome to these? I mean, we're looking at years of litigation? I mean,
I would like to think not.
Yeah.
I would hope that we can work forward without litigation. Obviously, New Mexico could sue. One of the tribes could. Utah could.
Right. I think that didn't they send their own notices of intent on that?
The tribes haven't.
No?
We haven't gotten anything from the tribes.
Not from to us. I thought that, or maybe mentioned that they were considering their own.
They did. The Navajo did.
Yeah, the Navajos.
And they continue to.
Yeah.
But we have not seen anything.
Right.
You know, one way to sort out facts is once litigation starts, then you have people in depositions and you are recording people's accounts of things and comparing them and saying, all right, Peter's account doesn't really make sense when you listen to Roger's account.
Yeah.
How do we reconcile that? It's possible that we have to go there in order to sort it out. I don't know. I can't tell yet, honestly. which direction this will go.
Yeah, I mean, and how important do you think that the letter from Mike King, and then the Interior Department's account, and then the EPA's own account, how important is King's letter going to be, in sorting all of this out? I mean, you said it might come to depositions, but when would those depositions occur? Only if a lawsuit.
Only if a lawsuit's filed, right.
Until then, what is there really to do to sort it out?
Well, I think you have to decide whether the most important thing is, and this is Cynthia talking to Peter, but
yeah.
is knowing exactly what happened or remediating the problem.
Yeah.
And I think the focus right now is on remediating the problem. But for some people, for Utah and New Mexico, it may be more important
Understood.
to figure out how much blame is apportioned to each of these parties. People who used to own the mine, the people who own the mine now, Colorado, EPA. People have different perspectives at different times. Right now, I think our focus, rightfully so, in Colorado is toward cleaning up the rivers and getting the NPL listing so that we can do an overall cleanup.
In your analysis up to this point, are you ready to make any statements or judgment as to a negligence on the part of the EPA or fault or anything? I mean, I know they've acknowledged fault, but have they really? Because they acknowledged fault. They said, yeah, we did this, but then, it was in consultation with and yada, yada, yada. So having been watching this closely, are you ready to say whether, the state's hands are clean and the EPA is truly at fault here?
Speaking of the EPA in that context, it's easy, I think, to admit fault. It's much harder to take responsibility and pay for the consequences of your actions. And I think that's what we're seeing now, honestly, which is what I was concerned about.
Do you think that the state is fairly does the state have a level of immunity here and not negligent?
I don't think we know entirely.
Yeah, okay.
Because we do have some differing accounts of what happened. Am I prepared to apportion who has what liability? I'm not. I don't feel like we know enough.
Sounds like Congress isn't done with, by a long shot with their investigation. So, yeah.
One thing I want to be clear on is we haven't foreclosed the option of litigation, and if, for example, if New Mexico files suit or Utah files suit against Colorado, what you historically see in environmental litigation is that everybody begins, just as you were describing, apportioning responsibility for negligence, and so we could file a cross-claim against any of the parties. And frankly, that's generally accepted practice.
Yeah.
Because we'll do everything in my office that we can to represent Colorado effectively. And if we are blamed for something that we weren't responsible for, then I definitely can see us filing action against other parties. But we've got to sort that out. And I think we're not there. I think it's also, from my perspective, I've given this a lot of thought, because if I was a member of the public looking at my actions as Attorney General, I would say, well, you sued EPA over hydraulic fracturing, you sued them over the Clean Power Plan, and WOTUS, why aren't you suing them in this instance? Peter, this is a very different case than the three I mentioned that we have joined as a state with other states against the federal government, because those are all questions of law and about who has the power. Does the federal government have the regulatory authority based on its grant from Congress, or is it the state under the Supremacy Clause that has that power? And in all of those cases, the common thread has been that I'm defending the state's right under those laws to make its own regulations
Mhm.
and not have them imposed by the federal government. What we have here is a totally different animal, because we have an environmental incident, a tort, accident or intentional or whatever you want to call it, that requires totally different approach because it's fact-based. And we've talked about that. What are the facts?
Mhm.
Who was responsible for approving the plan? Who was carrying it out? Was this the subcontractor of EPA? And did somebody from the state say, you have my blessing, go ahead? We also have to sort out, obviously, the damages. And so there are many factual questions that will be witness-specific, science and evidence-specific, and it's not the same situation that you've seen in the other cases where it was a pretty clear-cut, this is a question of law, who has the authority, the federal government, the state.
That makes sense. Great.
Thank you, Peter.
Thank you. I really appreciate it.